Thanks who just joined.
John Harris.
All right, John, it's David. Can you hear? Can you hear? Okay.
Yeah, go for it.
Okay. I'm gonna put it on mute for right now. Okay.
Hello?
Oh, it's dropped off. It hung up. So 8 to get an outside line. 877. You might want to write that down. 520-0013. And this is the PIN number. 81877-520.
0013. Oh, there you go. It didn't take the 1 and the 3 a minute ago.
Please re-enter your account code now.
Code 10 then. And if nobody's on there, This is David. Yeah, I just came up to the phone and it had hung up. So go ahead and try to call back in. I got the line back open back up. Okay. See what I mean? It'll keep ringing until the first person joins. So that was the guy that was on the phone. He said he got disconnected. So,
Alright.
so we'll see if he could.
So when he
These
calls in,
these
it
two
should
buttons,
answer.
yeah. These two buttons. Here's your volume up,
Yeah.
volume down, mute. So it's still.
Microphone gonna record what he says.
It should. So I'm gonna go ahead and call it 877-52. John, is that you?
It is.
All right. I don't know what happened. I came back up here and it had hung up or something.
Okay.
So if it gets disconnected, you'll have to call back in. It's 81877. You might want to write that number down in that code.
Okay.
And if anybody has a problem, they'll call this phone.
Okay.
So I'm going to leave it with you. It's on vibrate, so it doesn't disturb anyone. This is David. Who else just joined? Welcome. They're about to get started. So then I go up and tell her Sam Moore is on the phone.
Okay. You've been John too.
I mean, just your volume buttons right there.
Yeah, I saw that.
If you sit right here, you got the best view when I stand there. So, okay. You'll be able to see it from back there.
Hey, how are y'all?
Good afternoon. We'll call the meeting of the Advisory Council on Workers' Compensation to order. It's Monday, March 16th at 3:05 p.m. We are in the Legislative Plaza in Nashville in room 31. Ms. Schroeder, would you please call the roll?
Christy Allen.
Here.
Carrie Dove. Here. Bruce Fox. Here. John Garrett. Here. Bob Pitts. Here. Gary Selvey. Here. Paul Schaefer. Here. John Burleson. He said he was going to be late. Paula Claytor. Sandy Fletchall. Dr. Graves. Abby Hudgens. John Harris.
Here.
Lynn Lawyer. Jerry Mayo. Dr. Merle.
Here.
Greg Ramos.
Here.
Mike Shinnick.
Here.
Senator Johnson. Representative Eldridge.
We have 17, 19, 6. Oh, you are voting. 7 of 7 voting.
So we have a quorum, Ms. Schroeder, is that right?
Yes.
And do we have any members on the telephone?
2 members on the phone, John Harris and Dr. Merle.
For the record, the 2 members on the telephone are non-voting members. Their physical presence is not required for a quorum. Therefore, their participation by telephone is permitted. Before we begin, you'll notice that I am not Treasurer David Lillard. I'm Christy Allen. I'm the Assistant Treasurer for Legal Compliance and Audit in the Treasury Department and the Treasurer's designee here today. He has written a letter to the members of the council, and I'll share the high points of that with you. He regrets that he cannot be here. He had an unavoidable conflict. The Council on Pensions and Insurance is meeting right now in a couple of rooms down. Initially, that meeting had been scheduled for 1 o'clock, and Treasurer Lillard was going to be able to make both, and as he could not, and there is a Treasury Department bill that he needs to explain in the council, he has asked me to serve in his stead today, and it's my pleasure to be here. Before we get going, I want to also say congratulations and welcome to member Bruce Fox on his appointment as a voting employee representative, and he has spent 8 years as an attorney representative, so welcome. Also want to congratulate and welcome a new member, John Michael Garrett, who is new to the council as an employee representative, so thank you very much. The next item on the agenda, I think I've had a request to change around a couple of items on the agenda. So for those who have it, there are 3 bills at the end of the agenda: House Bill 1024, House Bill 1073, and House Bill 1246. I've been asked to move those 3 bills to be heard before discussion and consideration of House Bill 997. So without objection from anybody on the council, we'll move those 3 items up, and we'll take them up at that time. If there are no other changes to the agenda, we'll move on to the approval of the minutes. Do we have a motion for approval of the minutes from what was the last meeting?
October 14th.
From the
2014.
October 14th, 2014 meeting.
I move that we approve the minutes.
Is there a second? Second. Any discussion, any changes to the minutes? Seeing none. Ms. Schroeder, please take the roll.
Christy Allen. You
Approved.
vote on the, yeah.
Do I vote on this?
Carrie Dove. Bruce Fox.
Aye.
John Garrett. Bob Pitts.
Aye.
Gary Selvey. Paul Schaefer. Unanimous.
Thank you. The minutes are approved. We'll move on to new business. The first item under new business under legislation review is discussion and consideration of House Bill 0094 and Senate Bill 0105. Ms. Schroeder, I believe we have someone to present that bill.
Yes, Troy Haley, the attorney and legislative liaison for the Division of Workers' Comp, will introduce the bill and tell a little bit about it briefly, and then he'll field any questions that you may have.
Mr. Haley, welcome. If you could just introduce yourself again for the record so we get you on the tape, and then you can proceed.
Yes, hello. I'm Troy Haley, and I'm the – is this on? Can you hear me? Okay. I'm Troy Haley, the liaison for the Division of Workers' Compensation, and before I get started, I just wanted to introduce a couple of special guests that we've got in the audience today. Ken Switzer, Chief Judge of the Court of Workers' Compensation Claims, is here. There he is. And also Marshall Davidson, Chief Judge, or Presiding Judge, I should say, of the Workers' Compensation Appeals Board. There he is. All right. And what I'm going to do today is just give a brief, very brief summary of the division's administration bill. That's House Bill 94, Senate Bill 105. General update of the workers' compensation statutes. Lynn Schroeder, I believe, did a nice job of circulating the talking points, and her little blurbs and summaries I thought were very well done and pretty much summed up our bill. But I'll go through it briefly. This is primarily a clarification of the update, a clarification or a update of the Reform Act of 2013. That covers injuries on or after July the 1st, 2014, and the reform is still relatively new. Everything's going well, but we're really starting to get busier and busier with new law cases. This legislation would correct any inconsistencies in court procedures, filing fees, statutes of limitations, etc. And I think there's value added in all of this legislation. There are several sections here. As we've kind of learned in our internal lean training, we're trying to eliminate waste, eliminate excessive handoffs, add value, and make sure that we've got fair and timely determinations in our court processes. So the changes to the existing law will be, first, utilization review firms will be required to have URAC or NCQA accreditation to improve the overall quality of medical treatment and to ensure a level playing field for the providers of UR services. The majority of these providers are already URAC or NCQA approved, about 80%. Travelers, one of the top 6 providers, is not URAC accredited in Tennessee, but they are in other states, and it's probably an endorsement or something fairly minor that could be done to get that accreditation in Tennessee. In essence, the division does not really have the manpower or the expertise to monitor utilization review providers, so we would ask that this section be approved. Definition of qualified physician for pain management purposes will now be the same as the Department of Health's pain management treatment guidelines. This provides a higher level of training for pain management doctors who are providing long-term opioid-type treatment that's more than 90 days. Second injury fund. Attorneys will be paid from the fund, second injury fund, rather than the general fund. And the second injury fund is in good condition and certainly well able to pay its expenses. Administrator Hudgens had a good word for that, and I can't remember now what it was. Robust. The second injury fund is robust. It's in good shape. The Division of Workers' Compensation will be replaced in the code by Bureau of Workers' Compensation. The division is no longer a division of the Department of Labor and Workforce Development or any other entity. So for clarification purposes, we ask that name change be made from division to Bureau. Court of Workers' Compensation Claims has some minor tweaking as they have gotten into their court processes. Some things have come up. Statute of limitations will be extended for 2 years if permanent partial disability payments were made to an employee in an attempt to settle a claim without the Court of Workers' Compensation approving that settlement. Judges will be able to swear in witnesses, appoint guardian ad litem. In death cases, judges will have the ability to enforce judgments on uninsured employers as well. And the appeals board duties and procedures are set forth in great detail. That's several pages of our legislation is policies and procedures for the day-to-day operations of the Workers' Compensation Appeals Board. So in short, I know we got a lot of bills to look at, but that's sort of in a nutshell, that's my one-pager of the three-page talking points that you all have circulated today. So, but if there's any questions, we'll be happy to entertain those.
Thank you, Mr. Haley. Do we have any questions from the members of the council?
I have one question.
Mr. Garrett? Please use your microphone, too. There's a red button. Mr. Garrett? Push the button and use your mic.
Okay.
And pull it up.
On Section 10, it talks about appointment of a guardian ad litem for a claim. Was there a need that arises besides probate court, or just wanted the thought process behind that?
In the old law system, where workers' compensation specialists heard these claims, if there was a situation where we had a death case, we had to waive those out to the court system. Now that we've got internal judges hearing these cases, I think that part of it was not thought of when the Reform Act of 2013 was put together, and it came to light in a potential case that the court had this summer. So they thought that needed to be put in the code to give them the authority to appoint a guardian ad litem.
Other questions? Mr. Pitts?
I've got a question.
On the phone. Who's on the phone?
Language. Hello?
Is this Dr. Merle?
Yes.
Okay.
The language about the URAC and NCQA accreditation, are they accrediting the individual providers during the reviews, or is it going to be an accreditation of the insurance carriers or the UR organization that then has an internal means of accrediting their reviewers? And if it is the individual physicians, reviewers that are being accredited, what are they looking at? What makes them accredited?
If Administrator Hudgens would like to, she has subject matter expertise on this, and I think she'd like to address that.
That's fine, Ms. Hudgens.
Abby Hudgens, Administrator of the Divisions of Workers' Comp. The certification would be for the utilization review companies. It happens, they have to do that once they have it about every 3 years. It would not come up at each and every review. It's just like getting a driver's license. You have to do it so often.
But it would be the individual reviewing company that's accredited, not the individual providers they hire to do the reviews.
Yes, that's correct. Nurse Susie Douglas in our division has done a lot of research on this, and she got the statistics and these NCQA and URAC accreditation services. They actually go on site and do a full examination, provide assistance. There's a fairly substantial fee that's paid. My understanding is it's $35,000 for a 3-year accreditation on URAC. NCQA is $22,000, but that's only a 2-year accreditation, and I think to have a level playing field across the board, if 80% of the providers are doing this and making the effort and paying the fee that our medical department.
I guess my concern, when you say providers, you're referring to the UR review company.
Yes.
Not the individuals who actually do the review.
Correct. That's correct.
Okay. That's the language was just confusing. I know a lot of healthcare providers were confused and had just been contacting me about it.
I think that the UR providers would be firms like Liberty Mutual, Travelers, Gen X.
I agree. I just was wanting to clarify that.
Oh, that's a good question. Thank you.
Ms. Lawyer?
Mr. Haley, as far as the statute of limitations, is that only limited to compensable claims that there has been PPD paid out? Can you explain why you're extending the statute of limitations by a year on certain claims?
That's a good question. Under the new law settlements, a trend sort of developed over the last several weeks and back into the fall that insurance carriers were sending a check along with some documents for 1 times the rating, and here's your settlement, and it was not being approved. As you know, it might be that when that initial check is sent out and those initial documents are sent out, those other multipliers have not kicked in yet. And if that situation was a 1-year statute of limitations from the day that that initial check was cut, it might be beyond that, and there may still be some additional benefits due. So that's why that was put in.
Other questions? All right. Do we have a motion? Mr. Pitts?
Madam Chairman, subject to any other questions, I would like to make a motion that the Advisory Council recommend approval to the General Assembly of this proposal. I would encourage staff, this is not part of the motion, but I would encourage staff to get with Workers' Comp Council and be sure that those 2 points in which questions were asked are adequately passed on to the Standing Committee so they understand intent. That's my motion.
So we have a motion to recommend approval of House Bill 94, Senate Bill 105 to the General Assembly. Is there a second? Second by Mr. Fox. Is there further discussion? Ms. Schroeder, please call the roll.
Carrie Dove. Bruce Fox. John Garrett. Bob Pitts. Gary Selvey. Paul Schaefer. Unanimous.
Thank you, Ms. Schroeder. And Ms. Schroeder will communicate the comments to the standing committees as well. The next item on the agenda is House Bill 178, Senate Bill 174. Ms. Schroeder, would you like to give a summary of that bill, please?
By Representative Lynn and Senator Ketron, proposes to add the cancellation and reinstatement dates of workers' compensation policies to the list of 3 other items that are open to the public. So it's just adding those 2 items, adding the cancellation and reinstatement dates of work comp policies. Ashley Arnold is here to answer any questions the council may have.
All right, members, do you have any questions about the bill? Mr. Fox?
I move that we approve the bill for passage.
Mr. Fox recommends approval. Is there a second? Second by Mr. Dove. Is there further discussion on the bill? Seeing none, Ms. Schroeder, call the roll.
Carrie Dove. Bruce Fox. John Garrett. Bob Pitts. Yes. Gary Selvey. Paul Schaefer. It's unanimous.
Thank you, Ms. Schroeder. The next item on the agenda is House Bill 316, Senate Bill 581 by McDaniel and Overby. Ms. Schroeder, would you? Right.
Yes, this has been noted to be a caption bill.
Right. So what are the wishes of the council? Make a recommendation or take no action?
Flushed out, and then they're brought to us if they ever bring a body to the bill.
Okay, we don't need a motion for that. All right.
Yeah, Treasurer usually just pushes it off to the next meeting.
All right. So we'll push that to the next meeting. Next item on the agenda is House Bill 558, Senate Bill 171 by Eldridge and Ketron. Ms. Schroeder, would you please explain what the bill does?
This bill proposes language to specifically name the exempt construction service provider and independent contractor as exempt from premiums in order to clear up any uncertainty in the prior statutory language. Additionally, it requires defense and loss adjustment expenses be included in the reporting. Again, Ashley Arnold is available to answer any questions the council may have.
Mr. Pitts?
Madam Chair, I'd like to ask her to come forward and just simply say in about 3 sentences what the bill does.
Ms. Arnold, thank you. Would you please introduce yourself for the record, and then feel free to make your comments.
Thank you. Can y'all hear me?
You need to turn your... Are you on?
It's on. Okay. Can you hear me now?
Mm-hmm.
Ashley Gold, Insurers of Tennessee. You want me to speak up? This bill is being brought as a result of the Tennessee Court of Appeals case from last year, Continental Casualty Company versus Theraco, Inc. Specifically, as stated, this bill will slightly amend the language in the supplementary rate definition and also the loss adjustment expense definition to clarify that defense costs incurred under a workers' compensation policy are already included in the rate determination and should not be collected through a separate premium charge. I'm trying to do this in two. The intent of the bill is merely to codify and clarify how loss costs are calculated and to avoid full premiums being charged for individuals who have been determined to be independent contractors. It does not change the 7 factors for determining who is an independent contractor. If there are any questions, it is written that way for ease of codification at the request of the Codes Commission. Any questions?
Any questions for Ms. Arnold? Mr. Pitts?
Madam Chair, I'd like to make a motion that this bill be moved on with approval of the advisory, with a recommendation of yes for the advisory council.
All right. Mr. Pitts makes a motion for a positive recommendation. Is there a second? Second. Couple of seconds. Any further discussion on the bill? Seeing none, Ms. Schroeder, please call the roll.
Carrie Dove. Bruce Fox. John Garrett. Bob Pitts. Gary Selvey. Paul Schaefer. Unanimous.
Thank you, Ms. Schroeder. The next item on the agenda is House Bill 589, Senate Bill 1061 by Parkinson and Harris. Ms. Schroeder, would you please explain the bill?
This bill proposes adding prescription drugs that have not been prescribed by a Tennessee licensed physician to the list of drugs for the purpose of drug testing in the workplace. So if an employee is going to an out-of-state physician and has a prescription from a neighboring state's doctor, that drug in particular could still be tested as a drug for workplace incidents. Proposed language also indicates that employers should be certain that the drug was in the injured employee's system at the time of the incident and didn't enter the system at a later time.
Thank you, Ms. Schroeder. Is there discussion from the council on the bill? Ms. Hudgens, would you like to be recognized?
I would just like to point out a potential problem, or perhaps I'm not understanding the bill correctly, but when it says that you must consider drugs that were prescribed to the employee by an out-of-state physician, I'm not sure how the employer would know what those drugs are, and those drugs might very well be the same ones that are in the TDOT regulations, the DOT regulations. So it just seems to be that the way it's written may cause more problems than it corrects.
Other members of the council? Mr. Pitts?
Abby, would a potential correction to the issue you've raised been to make it clear that they're on our state's drug list? Or is it more complicated than that?
Ms. Hudgens?
It's not more complicated than that. I was just looking at how practically that would work itself out in the workplace, and it would almost make the employer have to do investigation, and there's no sign that they would even know what drugs were provided by an out-of-state physician.
Mr. Fox?
Somebody explain to me what problem this is intended to address. We have multiple cities who are on state lines, Chattanooga, Bristol, Memphis, Clarksville, where medical treatment may be received from someone just across the state line within the same metropolitan area. So where does that leave those individuals?
Ms. Hudgens? If you know.
Someone else here or on the council may know. All I know are the words of the bill as I read them, and that problem just jumped up at me. But I don't know what the intent was. Is the sponsor of the bill here?
It does not appear the sponsors of the bill are here. Mr. Pitts? Is there... if there's anyone in the audience who knows anything about the bill, they're welcome to come forward and make comments. And I don't see anyone jumping up, so it's back to the council.
Madam Chair, I have a recommendation in light of the fact that we are short on information and the workers' comp administrator has suggested there could be a technical problem. I would suggest this one be rolled to our next meeting and the sponsors be notified, and hopefully we can get additional information. I don't want to cause them harm by taking a bad action today.
Thank you, Mr. Pitts. Without objection, that will be rolled to the next meeting. The next item on the agenda is House Bill 654, Senate Bill 644 by Eldridge and Ketron. And I don't know if Representative Ms. Schroeder, would you like to?
The bill proposes language that an out-of-state construction services provider and its employer shall not have automatic reciprocity. Oh, you're not running. Okay.
Right.
Okay.
That's right.
Okay.
All right. So, given the word that this bill's not going to move this, we're going to roll this bill. So we'll take a look at this over the summer and come back next year. So without objection, that'll be rolled. Next item on the agenda is House Bill 821, Senate Bill 675 by Doss and Dickerson. Ms. Schroeder, would you please explain the bill?
This has been identified as a caption bill.
So consistent with what I understand the policy is that'll be rolled to the next meeting. Correct. Without objection, it's rolled. I assume the same that is with the next item, Ms. Schroeder, House Bill 895, Senate Bill 506 by Brooks and Johnson.
Has also been identified as a caption bill, yes.
So without objection, that will be rolled to the next meeting. We're going to switch down. The next item on the agenda, as we revised earlier in the meeting, is House Bill 1024, Senate Bill 1255 by Yarborough and Stewart. Ms. Schroeder.
And this also is a caption bill.
Without objection, that will be rolled to the next meeting. The next item is House Bill 1073, Senate Bill 1328 by Kane and McNally. Ms. Schroeder.
This bill proposes language which would allow entities that administer pharmacy benefits programs for Tennessee workers' compensation to fall outside the definition of a pharmacy benefit plan or program and therefore be exempt from the requirements of itemized reporting on each individual claim.
We'll turn it over to members of the council for discussion. Is there any discussion? Ms. Hudgens, I believe Mr. Pitts is curious to know your thoughts on this bill.
We defer to the wisdom of the legislature.
Mr. Pitts?
I'm not going to let you off that easy. Can you at least tell me, in your opinion, what the bill does?
Ms. Hudgens?
It is my understanding that there are certain provisions for in this bill basically related to TennCare and that type of program where that doesn't apply to Medicare, to workers' comp type programs. And so I think it's just a technical correction to make sure that there's no misunderstanding about that. If I believe this bill came last year or the year before. I remember the discussion about it where there was a concern that dental benefits under the state plan be exempted from this law, and this is something similar.
The bill proposes language which would allow entities that administer pharmacy benefits programs for Tennessee workers' compensation to fall outside the definition of a pharmacy benefit plan or program and therefore be exempt from the requirements of itemized reporting on each individual claim. Am I permitted to give my 2 cents?
Please.
It's my understanding that, as Abby said, this was a correction of just a clarification. Last year, the statute was changed, and they just sort of forgot to mention that the workers' compensation plans for Tennessee don't fall under this Disclosure and Reporting Act. And so this is sort of a cleanup language. It's my understanding.
Mr. Pitts? Okay, on the record, Mr. Pitts, Mr. Pitts had a question, which was for Ms. Hutchinson, I believe, was.
Does this deal with an issue of people who get workers' comp through the state, although it isn't workers' comp, or is it something else?
My understanding is this refers to TennCare expenditures, and that there are certain disclosure requirements of people who are making payments under TennCare.
Mr. Pitts.
And this makes clear that any benefits coming through standard workers' comp does not have to fit that reporting requirement?
That is my understanding.
Any further questions? Further discussion? Do members of the council want to make a motion on this bill? Or roll it to the next meeting? So would the council like to roll this to the next meeting and attempt to...
Let's roll it to the next meeting and ask sponsor to be in attendance, please.
Without objection, it's rolled to the next meeting. The next item on the agenda is House Bill 1246, Senate Bill 1247 by Holt and Green. Ms. Schroeder.
And this bill proposes language that a volunteer firefighter's wages for the purposes of this section shall be determined by multiplying their call rate times 40 hours, regardless of the actual number of hours worked.
Do members of the council want to discuss this bill? Seek further information? All right. Mr. Fox recommends approval. Is there a second? Second from Mr. Schaefer. Any further discussion?
Make sure we understand it. We're giving the volunteer firemen the comp rate comparable to a 40-hour work week.
Even though they don't work 40.
Correct.
Right.
That's what I thought it meant.
So it's my understanding that since they work odd hours and not always 40 hours, that they were having difficulty coming up with a comp rate. So they're suggesting that they base it on a 40-hour week, regardless of what their actual hours are for a work comp injury in a fire situation.
So, Mr. Dove, could you? Sorry.
So you're saying a part-time would have the same hourly rate as a full-time?
Well, these are actually volunteer firemen, so they don't really have times that I know of. I think they're on call. And they leave their regular place of employment and jump in their cars and go. But they may I'm not positive, they may have actual on-call hours. Say again. Salary? No, you're right, they have no salary. So how did they figure out that rate?
That's the bill. That's right.
Mm-hmm. So what is the rate used against 40 hours?
If I understand it, it's the same rate as a regular fire person in that department, that they're getting 40 hours instead of, if they show up for a fire, they're 3 hours, the comp rate's going to be based on 40 hours of work, not 3 hours of work if they get hurt on that job.
So since you were the one that moved in favor of this bill, I'm going to ask you this question. You're saying we're going to take a volunteer fireman. We're going to assume for purposes of calculating a workers' comp rate that they work 40 hours at the rack rate. Now let's turn that around. If they get injured, are we going to use that same 40 hours to establish benefits, etc.?
Yes, it would establish their comp rate. That would cover TTD and PPD.
So
I'm sure this doesn't come up very often.
So where we stand, we have a motion and a second. There's been discussion. Is there any further discussion from the members of the council or anyone else? You ready to vote? All right, Ms. Schroeder, call the roll.
Carrie Dove. Bruce Fox.
Yes.
John Garrett.
Yes.
Bob Pitts.
Nay.
Gary Selvey.
Nay.
Paul Schaefer. Aye. We have a split even
Procedurally, what happens there, Ms. Schroeder?
We make no recommendation.
Then no recommendation.
It goes out without recommendation.
All right. So the bill goes out without a recommendation from the council.
May I suggest the record show?
The record will reflect the voting on the
Please. Thank you.
matter. All right. The next item on the agenda is House Bill 997, Senate Bill 721 by Durham and Green. Ms. Schroeder, if you'd like to explain the bill, or if you have someone in the audience who'd like to do that, that's fine.
There's several.
Yeah.
Is Senator Green here? Oh, he is. Oh, there he is. Okay. So Senator Green will be coming up to explain the bill. This is the bill that's generally being referred to as the opt-out bill.
We like to call it the Tennessee option, but it essentially is similar to other states, what they call an opt-out. Senate Bill 721 is before you today, and thank you for allowing me to come and just share a few thoughts and what really our intentions are with this. I'm going to have to rush off to other meetings, as you know, and I have some subject matter experts here who can answer all of the thick glasses questions as you dig into the bill. But essentially, from the 100,000-foot view, what we're trying to do here, if you look at what's going on in states like Texas, where they have currently an option, where employers cannot be in the workers' comp insurance program, you have employee satisfaction that's higher than the insurance and costs that are significantly lower. If you compare our insurance rates per $100 of payroll in Tennessee, it's about $1.30. If you look at the workers' comp for those companies that opt out in Texas, it's 60 cents, more than half the cost. More than half the cost and better employee satisfaction. The other huge benefit of this is that companies retain the employee right there. I mean, their paycheck when they're in the workers' comp rehabilitation process comes from the company they work for. So this company, it's building its culture and its business, and then they get an employee who's hurt and they go off to an insurance. Or when the company runs the program, they're there with the company, and the company is shepherding the process, helping the employee come back to work. When workers' comp was, put together many years ago, back in the early 1900s, businesses were not very mindful of employees because there were lots of employees. Now we have to fight, we train, we recruit, we pay all this expense as employers, and then we have this employee get injured. We don't want to go through that process again. We don't want to pay to recruit, train, and get another employee in. We want our employee to come back to us. And so these companies are managing their own workers' compensation in Texas and doing a fantastic job. Now, recently Oklahoma has implemented one, and the differences are significant. In fact, they seem to take two extremes. In Texas, of course, there's no minimum benefits. Nothing required in the injury benefit plan from the state. However, the liability risk is completely on the employer. In Oklahoma, they opted to do just the opposite, to establish minimums that are identical to the state plan, but have no recourse. So basically, the employee couldn't sue for any extenuating circumstances that might be out there. We tried to take the best of both worlds and put them into this bill. There are minimums in this bill that the employer injury benefit plan must comply with. And we have an amendment on the bill addressing the issues that the administration brought forward to us. And we have that in front of them right now. It's actually being drafted in legal, and I apologize, we don't have it. Legal seems to be backed up with the pace that we're going. Hopefully we'll have that out of legal tomorrow, and you can get your eyes on it if you want. I believe these guys got a copy of sort of a summary of those changes, but we did everything that we could to address, and I think addressed every single concern the administration had. And again, it's at administration just to make sure that we did that. The amendment, though, brings the benefits to actually be better in many aspects than the current workers' comp system. So we have really, I think, created a bill here that is a huge win-win-win. We haven't left any of the industries out, and certainly the employees are going to be benefited by this system. And again, if you look at employee satisfaction in Texas, it's exceptional. So with that explanation and any questions you guys have, I'm going to turn it over to the thick glasses folks who know all the details about this thing, and I'm going to rush off to another committee meeting. So thank you, Chairman.
Senator, before you leave, may I ask one question?
Fire away. Yes,
sir. Do I understand there are amendments to this bill that are not implemented yet? That is,
yes, sir. We have the amendment at legal. Unfortunately, they're backed up right now.
So before us here today, we do not have the final version of the bill.
You do not. I'm sorry.
Thank you for clearing
yes,
that up.
Sir.
Representative Eldridge.
Thank you, Senator.
Yes,
I
sir.
appreciate you bringing this forward and being
thanks.
here today. Does the amendment coming forth, will it address all the issues that are happening in Oklahoma with the lawsuit that's going on?
I believe so, although I don't know all the details of the lawsuits in Oklahoma. You might want to ask that of some of the folks that we've got here to answer sort of those detailed questions. I know that as the administration looked at it and gave us a list, we took care of all those. And I looked at some of the other, like the insurance agencies and their issues with the bill. I think we've addressed all of those too.
Great, thank you, sir.
Yes, sir. That's a great question. You know, we just built a great system for insurance, and there's some companies though that if that system worked flawlessly would still want to run their own system. So why would we say, okay, municipalities, you can do your own option, but private industry you can't? I wasn't here. Well, again, as I said, even if your system that you just built works flawlessly, there are still industries in this state who would like to have their own option at the amended benefit levels. Yes, sir. You don't. Well, you have the a breakdown of them, I believe, on a table that we supplied you.
Members of the council? Any further?
I've got one question.
Yes, sir.
But Senator, doesn't it make sense to wait and see what effect the reforms that we just debated ad nauseum in this council and in the legislature and in the state to see what effect those reforms are going to have before basically revamping the entire system and basically throwing it out and allowing employers to opt out? I've got one other question too.
Well, let me answer that one first, and then I'll let you come back to the other one. The issue that's being raised here is, why not let this percolate out? And the point I'm trying to make is, even if it worked perfectly, there are industries out here who want to run the system themselves. So an option, they want the option. So again, it's great that those changes were made. We are still looking at whether or not they're going to be effective. I agree. But even if it was perfect, there are businesses in the state of Tennessee who want to have the same rights that we've given the municipalities in this state.
Also,
your second question.
The second question I wanted to know is, you're talking about employee satisfaction in the state of Texas. I'm interested in the source of that because I happen to belong to an organization of nationwide workers' compensation attorneys, and the reports I receive from the state of Texas are almost universal, not in employee satisfaction, but in their condemnation of the workers' compensation system, making it almost ineffective, almost totally ineffective for employees.
We will get you the data that we have. Yes, sir.
Other members of the council?
Thank you again for the opportunity.
Thank you, Senator. Mr. Fox?
Senator, in light of
yes, sir.
The fact that we don't have the final version of the bill in front of us, I would move that we defer any action on this bill or further discussion until we have the final version in front of us and have an opportunity to evaluate it and discuss it publicly.
Is there a second? Second by Mr. Dove. We have a motion and a second to defer consideration of this bill until the amendment's in its final form and there is further information provided to the council. Is there any further discussion on the motion? Seeing none, Ms. Schroeder, call the roll.
Carrie Dove. Bruce Fox. Aye. John Garrett. Aye. Bob Pitts. Aye. Gary Selvey. Paul Schaefer. Aye. It's unanimous.
Thank you, Ms. Schroeder. Thank you, Senator.
Thanks.
We defer to the next meeting. Thank you. That concludes the consideration of the legislation on the list for today. The next item on the agenda is a request from Ms. Hudgens, if I can just find it. I think Ms. Hudgens had asked that a subcommittee be established that would develop a new set of measures to be brought back regarding the statistical analysis that is done every year. We discussed this matter with Treasurer Lillard earlier today, and his recommendation was that rather than a subcommittee that would have to meet and do all that, that perhaps we start with the contractor, David Wilsterman, and you, Ms. Hudgens, and Lynn, to work together, consult with members of the council as appropriate, and bring back a recommendation for later consideration. If that's okay with you, without objection, that's what we'll do. All right, thank you. Is there any other business to come before the council today? Seeing none, do we have a motion to adjourn? Second? Second. All right, we're adjourned, subject to the call of the chair. Thank you, everyone.